We got an update on Amendment 3. Today, Missouri Secretary of State Jay Ashcroft decided to unilaterally violate the law and remove an initiative petition from the ballot. That's Amendment 3, the initiative that would put reproductive freedom into the Missouri state constitution. Now, attorneys supporting Amendment 3 have asked Missouri Supreme Court to hold Secretary Ashcroft in contempt of court for violating the law. Amendment 3 has been the target of a lot of litigation, and another challenge will be heard early tomorrow on September 10th, 2024 at Missouri Supreme Court. Missourians have a special constitutional right to put issues on the ballot. When we do, the Secretary of State must meet certain deadlines, including one to certify the ballot. The Secretary makes sure the ballot initiative complies with the law and enough valid signatures were collected. This year, the deadline to certify the ballot initiative was August 13th. The Secretary of State certified Amendment 3. As recently as just a couple of days ago in court, Secretary Ashcroft, represented by Attorney General Andrew Bailey, was arguing that he did a great job certifying the ballot. But a trial court made an unprecedented ruling, finding that Amendment 3 was insufficient on a technical basis and should not be on the ballot. That ruling had some problems, and it has been appealed to Missouri Supreme Court. That's what will be heard on September 10th at 8:30 a.m. You can watch my previous video on why I think the trial court got it wrong for 3 really big reasons, and those reasons will come up during argument tomorrow. September 10th is an important day because that's when the ballot must be finalized. So on September 9th, despite the Supreme Court issuing a stay pending their ruling, Secretary Ashcroft and Attorney General Bailey decided to entirely flip their position. Now they're arguing that Secretary Ashcroft did a terrible job, not a great one, and the amendment should not be on the ballot. Ashcroft then unilaterally wrote a letter claiming to decertify the ballot initiative, removing Amendment 3 from the ballot, despite him having no authority to do so, and despite the Supreme Court telling everyone to hold their horses and await a ruling. Secretary Ashcroft is wrong for a couple of big reasons. First, he was allowed to certify or not certify the ballot initiative on August 13th. That was his deadline. He has no authority in our Constitution or in our statutes and any cases to decertify a petition after that date. He is assuming an authority that he just doesn't have, just like Attorney General Andrew Bailey did before him when he repeatedly violated the law to prevent Missourians from collecting signatures on Amendment 3 for months and months. Second, the Secretary of State does not have the power to eliminate the people's constitutional right to access the initiative petition. If a secretary could decertify an initiative petition anytime that he wanted to, including on the day before or even the day of, when ballots are supposed to be finalized, the people of Missouri would have no recourse to stop him. Missourians have a constitutional right to collect signatures and put issues on the ballot. The Secretary has no authority to eliminate that constitutional fundamental right. This is more illegal behavior from our Secretary of State and our Attorney General. However you feel about Amendment 3, if our elected officials can eliminate our right to access the ballot, to vote on this issue, they can do it on any issue. We would be subject to the whims of big-headed politicians who think they own this place, who want to be king of Missouri. We live in America, and here we're supposed to have the power, we the people. It doesn't belong to some flip-flopping Secretary of State or Attorney General who think that they know better than us. The initiative petition is the people's strongest check on abusive government here in Missouri. And goodness knows we have an abusive government that needs a lot of checking.